Hi, my name is Joe Di Bartolomeo. I'm an Oregon injury lawyer. I have offices in Hillsboro, Oregon and Astoria, Oregon. And in today's video, I would like to talk about health insurance and the Oregon personal injury claim. Most of the cases that I handle involve auto collisions, but we also handle premises liability cases where somebody is injured on someone else's property. And in both of these kinds of cases, we are often dealing with health insurance having to pay our clients' medical expenses. And the reason I'm making this video is because there are special issues that go along with claims where health insurance is involved. And essentially what we're talking about is your obligation with your health insurance carrier to reimburse the health insurance out of any settlement or recovery that you make when you pursue your injury claim. So let's talk a little bit about these issues, and hopefully after the video, you'll have a better idea of how health insurance should be addressed when pursuing an injury claim in Oregon. So before we get into how health insurance works in the injury claim, let's put all of the insurance in the background. Because if you were to go to court against somebody who caused you an injury, there is no mention of any insurance in the trial. So we're going to put the health insurance in the background a little bit and just talk about what kind of claims you have, regardless of whether there's insurance involved or in the background. When we talk about health insurance, obviously we are talking about medical expenses, and medical expenses can be claimed as part of your economic damages claim. Now, I have other videos that talk about the different kinds of compensation that you can claim when making an injury claim, and you can check those out. Economic means it's objective, and medical expenses are an objective claim because we can hold up a medical bill and everybody will agree what that medical bill is. So that's what a medical expense claim is. It's a form of economic damages or economic compensation. And the term economic is just out of the statute. Now, what we're talking about is when the claim is made for your medical expenses, if your health insurance has paid any of the medical expenses, you and your health insurer or your health plan are in the same boat. And what I mean by that is each of you have suffered a loss. You have suffered a loss of your health. You have suffered lost income. You may have other losses that you're claiming. And your health plan having to pay medical expenses because of what somebody else did or how somebody else was negligent is also suffering a loss. And their loss, unlike yours, is a business loss. It's just money. They've had to pay benefits that they otherwise would not have to have covered. So that's why we have to really pay attention to your health plan and what it paid in medical expenses. Now let's get into why that is and how we handle that. When I say your health plan language, what I mean is the provision in your health plan that says we will not cover anything that is because of somebody else's negligence or carelessness unless you agree that out of any settlement or recovery, you're going to reimburse the health plan. And you'll see that we call it subrogation language. That's a legal term. Reimbursement provisions. It's in every health plan I've ever seen. And so when you make a personal injury claim, if your health plan is notified or finds out that you have an injury claim, you're often going to receive a questionnaire or at least a notice saying that you have to reimburse the health plan out of any money that you recover from the at-fault party. And sometimes you'll be asked to fill out a questionnaire that provides details. Now, it's interesting how the insurance companies find this out. Some of these health plans have algorithms that will look for certain words in your chart notes or in your claims documents like auto injury or personal injury or car collision or something like that. And it will trigger a process where a letter goes out to you asking if you intend to make a claim against another party. And you fill that out. And then what happens is the health plan will then sometimes have you sign an agreement saying that you will reimburse the health plan, again, out of anything you recover against the at-fault party. Sometimes the health plan, and this is something I see more often, the health plan will send your file out to what I'll call a subrogation firm, which is a company that does nothing but make sure that you reimburse the health plan out of any settlement or recovery that you make when you pursue your claim against the at-fault party. So let's talk about how that all works. The way this works is after your health plan knows that you've been involved in a collision and you give that information about your claim to the health plan will either assign somebody within their company. For example, if it's Aetna may have an office that deals specifically with getting reimbursed out of these claims that people make against other parties or other insurance companies. Or many of the companies will hire a reimbursement firm or a subrogation firm that will gather all of the medical records and medical bills and the explanation of benefit forms, which show what was paid and how much. And then they will be in touch with you or your lawyer, and they will provide a ledger of the accident-related medical expenses. Now, what we do in our office is when we get those ledgers, we are making sure that the ledger is accurate. And what I mean by that is the bills listed in this ledger are actually accident-related, because many of our clients will go in for routine medical care, or they may have some other medical problem they're getting care for. And you'll often see that type of bill included in the ledger. Well, it's not related to the collision or the accident, so we will let them know, and then they'll revise the ledger. Now, once we have the ledger, then as our client's case goes through the process, we will get to a point where either we go to trial and there's some form of recovery, or more often, the case is resolved by settlement. Now, the key here is to make sure that you have an accurate idea of what the health plan has paid, because out of any settlement recovery, you are going to have to reimburse the health plan. So let's talk about issues of reimbursement next. So there are a couple of issues that go along with reimbursing the health plan out of any recovery that you make. And I'll just cover a couple of common issues that come up. The first one is whether the health care plan, your health plan, is willing to share in the attorney fee if you have a lawyer involved. Are they willing to share in the attorney fee that you incur in pursuing the claim? Now, what I mean by that is, let's say that you pursue a claim against an at-fault party or their insurance company, and you make a recovery. And let's say your health plan has paid $9,000 in benefits. So under the reimbursement provisions in your health plan, out of your settlement, you'll have to reimburse your health plan $9,000. But here's the thing. There are different kinds of health plans out there. Some of them will insist on getting every penny they paid, but more often they will have a provision that says, look, if you're pursuing an injury claim against another party or another insurance company and you have to have a lawyer help you with that, they're going to charge you a fee. Since you recovered our losses, we should share in that attorney fee. And the way that works is the health plan will take a discount. So our $9,000 example, the health plan might say, well, we will reduce what we should be reimbursed by 1/3, or we will reduce what we should be paid by 25%. It just depends on the language in the health plan. And they vary from health plan to health plan. So that's one issue that we commonly see with these cases. And we will negotiate directly with the health plan or whoever they hire to recover their interest in the case. The other issue that we'll often see is issues of liability. And what I mean by that is you may have a claim against another party or an insurance company, but there may be an issue about who actually is at fault. For example, you may have been involved in an auto collision where the collision occurred in an intersection. The duties or legal responsibilities of each driver entering an intersection are the same. And there may be some dispute about who was at fault and if so, how much. And there's this concept in Oregon of comparative fault. And I have videos that talk about comparative fault, but basically we're talking about situations where the fault may be shared between two drivers entering an intersection. Well, what's going to happen there is if you go to a jury trial in Oregon anyway, and you prove $1,000 in damages, but the jury also finds that you are 50% at fault, that $1,000 verdict will turn into a $500 verdict because Oregon law says that the verdict or the amount of damages you prove is reduced pro rata or by the percentage of your own fault, up to 50%. So if that $1,000 verdict turns into a $500 verdict, then you've only recovered 1/2 of the medical expenses that you incurred. In those kinds of cases, we may go to your health plan, explain what happened, and they may further reduce what they expect for reimbursement. We also may have a case where just the idea of proving liability is an uphill battle, and we may be in settlement negotiations and go to your health plan and explain the facts of life about the liability issue in your case and negotiate the reimbursement to the health plan based on liability issues. So there are many other examples of where the negotiation with your own health plan for reimbursement can vary, and it's a fluid situation. There are many issues that can affect that. So that's how health plans are involved in injury claims. These are the special issues that you may encounter when you're pursuing a claim and your health plan has paid medical expenses. Now, if you have other questions about this, check out our free Oregon Personal Injury Guide. I will leave a link in the YouTube version of this video below. And then if you're looking at this video on my website, there is a special offers page up top that you can check out, and you can download the free injury guide. Also, if you are curious, have other questions, the contact link I'll leave on the YouTube version is down below. And then on my website, I believe it's, and I don't know if my finger's in the right direction, but it's up here somewhere. You'll see the contact us icon, and you can contact us if you have any questions. If we're not able to help you with your case, we will find somebody that can, or at least give you information that will help you know where you stand with these kinds of issues. I hope this video was helpful. Thank you so much for watching. Take care.